I've been doing closings. We've been doing closings since 2001. We're currently located, next slide, please, sir. We're currently located on 285 Paces Ferry Road, 2727 Paces Ferry Road, Suite 1450, Atlanta, Georgia, 30339. We also have a satellite office. And with that being said, we can do closings out of the office. If we know in advance where you all want to close, we can arrange to close at other locations, because real estate is all about one thing: location, location, and location. And the same is true when it comes to having the closing. We want to make sure that it's convenient for you and your client. So if our office is not convenient, please let us know in advance, and we will try to locate a similar place to conduct the closing that is professional and has all the needs that we have as far as conducting that closing. Next slide, please, sir. We also have signed up a new title company, and as part of the title company, we now have a full-time in-house commercial branch. We can do commercial closings from $200,000 to $200 million. So if you have any commercial deals that you want to send our way, we have a full-time title examiner and team, and all they do is process our commercial deals. Next slide, please. All right. And Mr. Ragsdale, you probably see more real estate contracts than I do. So if you want to chime in at any time, please do. But the topic of today's briefing is the purchase and sale agreement for 2023. And what I want to do is slowly go through this. So I hope you all have one of these readily available to you so that you can look at, because what I want to do is go through the key terms and conditions to make sure that you understand how to fill this contract out. And I want to say this many times today: please make sure that when you're filling out your purchase and sale agreement, if you want to add special stipulations, use the special stipulations that are in the drop-down boxes versus you trying to get your own special stipulations. I have a lawsuit going on right now, and I'm representing the builder. The builder had somebody come to them with a pre-printed regular real estate contract, which was the first form for new construction. They should not be using the regular purchase and sale agreement. The agent for the buyer went in there and put in her own special stipulations that contradict with the actual contract. And now we're in a lawsuit because the question is, when did the contract expire? Did the seller breach contract, or the buyer breach contract by not closing? And all this confusion is caused by the special stip that an agent wrote by themselves. The special stipulation section with the drop downs, all of those drop down options were vetted by the author of the actual real estate contract for the Georgia Real Estate Commission. So with that being said, I'm going to jump straight into this, and under A, key terms and conditions. Number one, purchase and sale. 1A, the property address. To me, that's the most important piece on this contract. Please make sure you put down the property address. If the property address includes more than one parcel, please let us know that up front. We've had examples where somebody's buying two lots of land and they did not put down both lots on the actual contract. So make sure you fill out the full address. That's under Part A. Part B talks about the legal description. A lot of times it's been my understanding that agents do not have the legal description. So most times that part there is left blank because agents do not have access to GSCCA or don't pay for that, or the seller does not give them a copy of their previous warranty deeds. Therefore, they do not have the legal description of the property. And I just had this happen recently in my office also. A young lady was buying a parcel of land and said, "Hey, Leonard, here is the tax ID. I don't have a legal description. Please run a title exam on this parcel ID." My office ran a title exam on that parcel ID, sent it back to her, and she started complaining and then realized that she'd given me the wrong parcel ID number. So make sure what you give to the attorney or what you fill in is actually correct, because that is driving everything that is moving forward. A2, purchase price. That's pretty straightforward. Let me say this. If the purchase price changes at any time, please make sure the closing attorney and the lender have a copy of that updated sales price or reduced sales price. Number 3, closing costs. Put in any closing costs the seller is paying. Number 4, closing date and possession. These things can change. We may close today, but possession is a week out or a month out, and we're doing a lease back. So if there are changes, or if there is typically closing and possession are the same. If they're not the same, please indicate that. Another issue I've seen on 4, it says blank o'clock. And I've had people put in 12 o'clock and then hit PM. Well, 12 PM is technically noon. 12 AM is the next day. So if you're trying to get to the last part of that day, put in 11:59 PM. So therefore, that means you have up until midnight, because midnight is technically AM of the next day. And I've actually had a lawsuit based on that. Number 5 is the closing firm. I will help you all out with that pretty easily. The closing firm is Medley and Associates. Our phone number is 770-319-7592. Number 6 is the holder of earnest money. And this is where Mr. Ragsdale and I get into our biggest disputes sometimes, because at this point, nobody likes to hold earnest money. Why? Because holding earnest money is almost a free task unless there's a problem. Now you're spending money trying to fix the problem. We know this one thing when it comes to earnest money. The earnest money does not belong to myself, my firm, or to Mr. Ragsdale. That earnest money must go in an escrow account. So with that being said, to protect Mr. Ragsdale, if Platinum is holding earnest money, make sure you all deposit that money in the correct account, his escrow account, not his operating account. If the closing attorney is holding earnest money, please fill out the F511. I have this happen a lot. Earnest money hits our account. We've not seen an F511, or we get the F511 and earnest money was due 3 days ago, and that's technically already a breach of contract. Make sure these things happen in unison. We'll also go over later on as far as earnest money being released. Number 7, checks how earnest money shall be given. We have check, ACH, cash, or wire transfer. Mr. Ragsdale, does your firm accept earnest money via ACH?
Yes, we do. And earnest money at Platinum Real Estate. So we have a portal. That portal explains, well, let me go a step further back. At Platinum Real Estate, number 1, we have a dummy sales contract. It's an example that allows you to fill in all of the areas with an example. You can always call our corporate office and we'll obviously help you. Earnest money, there are specific steps and procedures you have to follow at Platinum Real Estate. If you're not with Platinum Real Estate, all brokers have policies and procedures on how to handle earnest money. Now, Mr. Medley is 100% correct, right? You don't want to put the earnest money in the wrong account. You do not want to follow wrong procedures. So if the closed attorney is holding the earnest money, contact Medley and the Associates. Hey, how do you want me to handle the earnest money? Platinum Real Estate, we have it all online for our agents. But you want to contact the holder of the earnest money and then follow the policy and procedures of whoever's holding it.
And my caveat to that is, or my piggyback to that is, our firm is not allowed to accept ACHs. ACH is like a wire, but it's not a wire. We will accept a wire. We will accept a check. We do not want cash, and we cannot accept an ACH. Our ACH block on it. The reason being, if somebody sends you an ACH, they have the right for up to 90 days to reverse that ACH. So therefore, an ACH is not like a wire. So if the attorney's holding earnest money, it must be a wire or a check. Next, we get into inspection and due diligence. Due diligence means that for so many days, this gives the buyer the chance to back out of this contract. And what I typically see in there's 10 to 15 days of due diligence. Just realize when you're doing your due diligence, this is the time period that you must have your inspections done or go by the house. If you want to, you're trying to find a reason if you want to back out and protect your buyer as far as getting your earnest money back. Then we have an option under there that you can actually extend the due diligence by paying $10 non-refundable, and that will actually get you more due diligence, period. Next slide, please, Mr. Ragsdale.
Let's do this. Questions, real quick. Questions. Questions. Raise your hands. Show of hands. Any questions about contracts, contract situations, anything that we've learned so far? Questions, anyone? Let me see. Do I have any hands up with questions? Or you can shoot the question through the chat. Questions. Or you can also shoot it through the Q&A as well. Okay, we have a question here. Let me unmute you. Yes.
Hi, everyone. Good morning. Can you guys hear me?
Yes, hear you fine. Good.
Hi. Hey, good morning. I just have a quick question. So I'm a new agent and I really have zero experience with trading. So I just had a quick question about where the earnest money is going. So I was under the impression that the earnest money goes to the broker's own earnest account. Does it have to go through the lender's account?
Well, I can kind of help you with that. Everything is negotiable. Now, you're in the coaching program, so we got you. So at Platinum number 1, I'm going to coach you through it. I'm going to help you step by step. So you're going to contact me, and I'm going to give you all of the right answers at that time. So number 1, I want to coach you. Number 2, the correct answer is it's negotiable. And you want to, when you're filling out that contract, right? We know Platinum Real Estate is authorized to hold earnest money. We know the closed attorney, Medley and Associates, they can hold earnest money. Now, every real estate broker is not authorized to hold earnest money because when I received my broker's license, I had the options to 1, have a trust account and hold earnest money, or 2, I could have said, I don't want a trust account. I don't want to hold earnest money. I don't want nothing to do with it. So when you're in a deal dealing with another agent, dealing with the other brokerage firm, that other brokerage firm may or might, or maybe they can't, or maybe they can hold earnest money. But when you fill out the contract, the key answer is it's negotiable. So if you put the other agent, and the other agent might say, no, I'm not authorized to hold earnest money. No, I'm not going to hold it. So it's negotiable. Then you can say Platinum Real Estate, or you can say Medley and Associates. So it's 100% negotiable, but don't worry, you won't mess it up because we're going to coach you through it. Fair?
Okay, yes, awesome. Thank you so much for your answer.
Medley, anything you want to add to that?
I will say this, being the holder of earnest money, in my opinion, does not give you any extra leverage. So don't let who's holding earnest money be a deal breaker of the transaction.
Boy, preach. Boy, I wish I had $1 for every time a real estate agent want to argue and negotiate over who holds earnest money. It really doesn't matter. We all have the same rules, regulations. It's really no big deal. So look, you said $1 million statement right there. And a lot of times, and I'm sure you have seen this too, agents get all bent out of shape and upset and get all emotional over who holds earnest money. Who cares, right? Who really cares?
And with that being said,
yes, go ahead.
It doesn't matter who holds it, but if you're not the person holding, or if your firm is not holding it, do get proof of that deposit.
Yes, indeed.
I've had a lawsuit. I've seen agents being sued because that agent told me they were holding earnest money and the money never hit the account. Deal fell sideways. Seller wanted the money. Like, oh, we never got it. Now the broker has a problem. The agent has a problem. So if you say you're holding earnest money, get proof of that deposit.
And what would be considered adequate? Oh, sorry.
Huh? Go ahead.
I was going to ask, what would be considered adequate proof? Like a receipt of, like, what would you consider adequate proof?
If it's a wire confirmation, if the attorney is holding it, something from the attorney in writing saying I have it.
Okay.
If it's another agent, I hate to say it this way, you're trying to pass the burden from yourself. You need to have proofs. Therefore, hey, I know that earnest money is actually there, because the worst I had this happen. Hey, earnest money is $15,000. Nobody ever got it. The seller said, well, we didn't close. I want the money. And the agent's saying, oh, I thought you had it. I thought you had it. Nobody ever got proof of the actual earnest money. So you need a copy of a receipt, an email confirming from somebody that, yes, we are holding earnest money. So therefore, if there's any issue, you have a written piece of paper to fall back on.
Okay. Thank you so much.
Now, with that being said, Platinum Real Estate, policy and procedure states two things. You are required to upload a copy of the earnest money to Platinum DB within 24 hours of any signed contract. So when the buyer and the seller and everybody sign that contract, Platinum Real Estate Agent, you have 24 hours to get a copy and to upload it to Platinum DB within 24 hours. So at our firm, if you want to get paid in our firm to be in compliance, you are required to upload it within 24 hours. If you go close a deal at Platinum Real Estate and you do not have a copy of the earnest money, we will not pay you until you have uploaded a copy of that earnest money. You have to have it. If you put a contract in our system and 48 hours go by, 72 hours go by, and we do not have a copy of that earnest money, you will receive a call from my closing department. Listen, you have to upload a copy of the earnest money or this deal is off. So as Platinum Real Estate Agent, our policy and procedure, if you're not a Platinum Real Estate Agent, you should have your own policy. When you write a contract, when it is signed by all parties, that earnest money gets uploaded within 24 hours, unless there is a stipulation saying, hey, my buyer's out of town and I will upload it 3 days after binding or 4 days. Okay, then you have 3 days to upload it because my buyer's out of town and I can't upload it for 3 days because of a special situation. In this day and age, 2023, there's no excuse at all to not really have that earnest money within 24 hours. I don't care where you're at in the world, you can typically get me that earnest money within 24 hours. You are covering you are covering your client, and you're covering your broker. Okay? Have another question here. Question says, Mr. Medley, is a contract valid / legal without earnest money?
My initial answer is no, that it is not, because you must have offer, acceptance, and consideration. The earnest money is considered part of the consideration, or is viewed as an option contract because that seller is agreeing to take their house off the market and sell it to you, and that earnest money is what makes that binding. If you put $0 in it as earnest money, you could, and everybody signs off on it, that could be a legally binding contract, but I believe earnest money is required to make it a full contract. So let me say it this way. It may not be a contract without earnest money, but it could be an enforceable document. The earnest money makes it a contract.
Does that answer your question? Good. Great. Okay. Let me see. Do I have any hands up here? Let me see here. And let me mention this. So let me just make this statement about earnest money. And you guys should probably remember this from, somebody else asked, is earnest money optional? Listen, you guys remember this from real estate school, real estate school 101. Number one, just like Leonard said, earnest money is consideration. There's a lot of things that can be consideration. I can put up my motorcycle, I can put up my car, I can put up my watch, my ring, I can put up my glasses. It's of value. So a lot of times we say, hey, you know what? Does it have to be money? Well, it can be something of value that we all agree. I can say now, 99.999999%, that'll never happen. But legally it could. Y'all remember real estate school? Well, some of y'all may not remember, because y'all went to real estate school so long ago. But if you remember real estate school, right? Anything of consideration. All right. Excellent. Any more questions? Raise your hand. Questions, hands with questions, or you can shoot me a question in the chat. Let me see. Chat. Is earnest money optional? Here's another question. Is the closing date mandatory for a contract?
I will not say that the closing date is mandatory for a contract, but if you don't have a closing date in there, you just created a significant problem. And that goes back to the problem I have the closing I was mentioning before. And the special stipulations, it had for closing date said TBD, see special steps. Special steps says no matter what, this contract shall close 6 months from the date of acceptance. So there's not an actual date in there. It gave a parameter. Now the question becomes, if I don't put a closing date in there, nobody wants to be in a contract forever. If the closing date is left open, you could say what's reasonable. And so now you have a very loosely interpreted contract. So I'm not sure where the reasoning for that question comes from, but a closing date is needed in order to make it a not enforceable, not binding, but a sufficient contract that can be easily interpreted, because there's nothing left to interpretation at that point.
Excellent answer. Excellent answer. Let's talk platinum real estate. At Platinum Real Estate, if you will submit a contract to us like that, you will receive a call from our closing department saying, hey, what's the closing date, right? We don't do 6 months, 9 months to be determined. We're not doing that at Platinum. Why? Because you have a responsibility, right, to cover your client. Now, can you do it? I guess you can, but that's not what's best for you. That's not what's best for your client, just to have it open-ended like that. So at Platinum, you're going to receive a call from the closing department saying, hey, we have a problem here. We have to update this contract. We need a firm closing date. Okay. I think I have a hand up here. Yes. Miriam, you're free to talk. What's your question?
Okay, I have two scenarios. One scenario, I have a person that has their real estate had put a closing date, but it says on or about, right? So it's been like 7 months later, and they still haven't closed, nor refuse to get, plus they refuse to give back the earnest money. How does that work?
Well, in my opinion, that's one of those ones I think you're headed to court, because it says on or about. To me, that about could be interpreted 3 days before, 2 days after. I think 6 months is not about, but that's a question for a jury or for a judge to decide, because all these questions lead to one thing. If you're the holder of earnest money, who are you releasing the earnest money to? And based on what you just told me, I would have a hard time releasing it to anybody because we've not closed yet. That'd be hard to say that's a breach. Therefore, I would interplead the money into the court.
Okay. Second scenario.
So, well, all right, let's go back to first scenario. Let's go back to first scenario. Let's broker. Okay. Platinum Real Estate. The deal comes to us. If I'm coaching you, what I would say is, when I would look at that, the correct thing, what it should have said is on or before X date. So for coaching, for education here, when you write the contract, you want a specific date, bam, okay? Then everything else you do on or before. Everybody gets that. It's on March the 3rd or before. So I can close before. But March 3rd is the drop down dead date. So this is going to close on or before March the 3rd. March the 4th, I'm out of contract. That's very clear. But I can do it anywhere before. Does that make sense?
That makes sense.
All right, good. Now, phase 2. What's the second part? What's the second part?
Okay, the second one is I had a contract, and the other real estate agent switched the form to whatever form they wanted to use, right? And when we went to close, when we had the bank appraisal, the property was $90,000 over what the appraised value was. So the bank wouldn't approve it because of that point, and they refused to give the earnest money back. Come to find out, the original contract that we submitted to them, they changed it to what they wanted to. So when the buyer took and re-signed the contract, they thinking they signed the same thing. It ain't even the same form, and they still haven't refunded the money back. And they refuse to reduce the property to what the appraisal was.
Okay. So we're talking about contracts. So let's talk about one area. Mr. Manley, you want me to go on and tackle this one?
Go ahead, sir. I think I know what she's saying, but go ahead. I'll chime in.
Listen, as a broker, I see this all the time. Here's what we have to remember. There's 3 typical contracts out there. Georgia MLS have a contract. FMLS have a contract. Then there's GAR forms. So those are 3 different type of contracts. Now, there's also contracts that you can pull off the web. Legally, you can write a contract on a napkin and everybody sign it and you're good to go. Now, we wouldn't do a napkin, but you get where I'm going here. So don't get caught up on a specific form. There's a lot of different forms. You can go online and pull off a form, and if everybody signs it, it's legal. You can type up something, and if the buyer and seller and everybody signs it, it's legal. So don't get caught up on switching the form, because if it's in print and everybody signed and everybody agreed, don't get caught up on this form or that form. A lot of agents do that all of the time. Well, I only want a GAR form, or I only want an FMLS form, or I only want a Georgia MLS form. Look, a contract is a contract, and if you sign it and everybody sign it, that thing is binding. So don't get caught up. If an agent, and here's the learning point, if the agent emails you a contract, you have to review it with your client, explain it with your client, and then sign it. If you don't understand, or if you don't agree with what that contract says, don't sign it. Don't get caught up on this form or that form. Make sense? Now, Mr. Medley, help us with a little more on that one.
Well, and what you said is very valuable, Mr. Ragsdale. A contract has 6 elements: offer, acceptance, consideration. Buyer, seller, consideration is the money and or the house. You must be of sound mind. You must be of legal age. And you must have the intent to enter into a contract. So with that being said, I really don't care what your contract is written on. When it comes to land, we're talking about land and a house, that contract must be in writing. So there is no verbal contract for a sale of a house. After that, there is no verbal verbal contract for a house. Number 2, the contract must list the buyer, the seller, the property address, and the sales price. If it lists those things right there, that could be considered a valid, enforceable contract. What I heard you say, I may have misheard this, is You started with one contract. When it came back over, they had used a different contract and somebody assumed it was the same. Never assume, as Mr. Ragsdale said, you must make sure that none of the verbiage has changed, or why did they switch contracts on you? Because once you signed it, I have said all the time, oh, I thought it was the same contract. I didn't intend to do this. I didn't intend to remove the appraisal of this. That is your contract. You're stuck with that contract, and you've done your client a disservice at that point. So be careful of what you're signing and what you're assuming is being the same.
Absolutely. And you know what? I wish I had $1 as a broker, how many times I see agents signing it because it's an FMLS contract, or sign it because it's an MLS contract, or I just love GAR form. That's another thing. Oh, I'm not signing nothing unless it's a GAR form. If it's not a GAR form, or if it's not an FMLS form, I'm not going to sign it. No, it's what you're signing, not the type of form. Here's another one, that I see a lot. All of this electronic signing. See, that's another one. When you receive it electronically, you are signing just like if you sign it with a pen and paper. So be careful with that as well. You can't say, oh, I didn't read it because I electronically signed it and I just signed it being quick and I didn't read it. No, if you sign it, whether it's electronic or not, that's your contract. Okay.
And we're not there right now, but what Mr. Ragsdale just said is very important. The last thing we're going to talk about is signatures, and based on the time, we may not make it there today. When you are signing the contract, everybody sends these contracts out for electronic signature. If your client happens to be a company, if Metley and Associates is buying a property, my signature can't be Metley and Associates. Metley and Associates is a fictitious thing. Leonard Metley as member must sign. So make sure that your signature blocks for your contracts are correct. I have a lawsuit now because they're saying, oh, that's not a valid signature on the contract because it was signed by, and I think what happens is when you all send off an electronic signature, it pulls the name of the buyer or the name of the seller out. It does not give you the ability to add a title for the name or the buyer. Is that a true statement, Mr. Ragsdale?
Yes, you're correct.
Okay. So we're finished. We're almost finished with page 1 of this. Number 11 is very important. Time limit of offer. Please make sure that you fill that in. You must say how long this offer shall remain open. It shall not remain open for an indefinite period of time. On to page 2. Page 2 is pretty much just a definitions page of the contract. There's a purchase and sale warranty where the seller is saying, yes, I own the property and I can transfer the property to you. Mr. Ragsdale, go to the next slide, sir. Thank you. So this is page right there. Yep, right there. Further explanation. This is page 2 of the contract. And this page is a fairly new page of the contract. And what it does is it defines what the seller's rules are, title examination, what is title insurance, lender's policy versus an owner's policy. It discusses what closing costs are, talks about prorations, the closing date, the right to extend. So question for you all, because this has changed. You have a unilateral right to extend the contract for how many days? And I can't see the answer, but look at number 4, for 8 days. So either side may extend for 8 days automatically. The buyer shall have the right to choose the closing attorney. Holder of earnest money will be paid in such a way that we are talking that you all decide. The holder of the earnest money, they have the choice to make the decision who the earnest money goes to. If they cannot decide, under 7C, if there's an earnest money dispute cannot be resolved after a reasonable time, holder may interplead the earnest money into a court of competent jurisdiction. That means that I'm handing the earnest money over. All parties hereby agree to identify the holder harmless from and against all claims, meaning that if I make a decision with the earnest money, you can't turn around and sue me because you don't like the decision that I made. Inspection and due diligence. This is part of the first page of your contract, your inspection and your due diligence. When does that period start? When it ends, what does that mean? When due diligence is over, that means that that earnest money has gone hard. It is no longer up for return to the buyer unless the seller somehow breaches the contract by not giving clear title. Mr. Ragsdale, how often do you all require or ask for inspections on a closing?
Well,
They're not required.
an inspection isn't required, and it really depends on the deal. It depends on the buyers, and it's really wide open. I have had people pay in cash. They say, I don't care about an inspection because I'm rehabbing it anyway. A lot of times with investment properties, folks will say, hey, I'm rehabbing it anyway. I know there's issues. I don't care about the inspection. It's really up to your client. Legally, it's not required. The mortgage company, if you're getting financing, they don't really require it. So it's really a case-by-case type of basis on the inspection.
Okay. Next, we're gonna go next slide, please, Mr. Ragsdale. Default. Well, default means that for some reason we have not closed. And now the question is, what do we do? So this is on page 5, number 2 at the bottom. Default, remedies of the seller. If the buyer defaults, the only remedy the seller has is to keep the earnest money. The seller cannot sue for a specific performance. So once again, the seller's only remedy is to keep the earnest money. The parties expressly intend for the earnest money to serve as liquidated damages and not as a penalty. The buyer, if the seller breaches, the buyer's remedy is specific performance or to cancel the contract. Rights of the broker. In the event this agreement is terminated or fails to close due to the fault of a party hereto, the defaulting party shall, as liquidated damages to every broker involved in this agreement, pay commissions that they would have received. So the buyer may be responsible. The buyer cannot be forced to buy the house, but the buyer could be forced to pay any commissions. Most important, 2D, attorney fees. In any litigation or arbitration arising out of this agreement, including but not limited to breach of contract claims between the buyer and seller and commissions, the non-prevailing party shall be liable to the prevailing party for reasonable attorney's fees and expenses. So there are ramifications if you are in default of the actual contract. Risk of damage of property. This is important. The property belongs to the seller until we close. The insurance policy of the buyer shall go into effect the day of midnight the day before closing. So even if the seller is taking the house and staying longer, the buyer must still have insurance on that property. So please make sure that all properties are always insured. Next slide, please, Mr. Ragsdale.
I have a couple questions. Let me put a couple questions here. A question says, is there a difference between special stipulations and contingencies?
Yes. A contingency means that if I have, a financing contingency means that if I don't obtain financing, there is no contract. If there's a 15-day financing contingency, I have 15 days to get financing. If I don't get financing, there is no contract. A special stipulation is a stipulation within a binding contract. So yes, they are different.
Perfect. Now, I have another question here. This question says, I'm sorry you mentioned extending something by 8 days. Can you please expand on that?
So a contract has a closing date of March the 1st. If the buyer is not ready to close at that point, the buyer has the right to unilaterally extend the contract for 8 days, meaning that they now have until March the 9th to close, and there's nothing the seller can do to disapprove or to stop that.
Now, let me mention this. You have to read your contract. Why? Every contract isn't written like that. You got your GAR forms, you got your FMLS contract. You have your Georgia MLS contract. You have contracts that you can pull off the web, right? Remember what I said. If everybody signs on you, you have to read and know what you're signing. So I don't want, as a real estate agent, you just say, hey, I have an extra 7 days. No. It depends on which contract you are using. FMLS contract is slightly different than the Georgia MLS contract, which is slightly different than the GAR form. Right now, I believe Linda's talking about the GAR form. It's a part of that form. Georgia FMLS a little different.
Let me go back. I should start the presentation with this. The contract that I am reviewing today is the GAR form. So the stuff we're talking about is GAR related, GAR only.
Here's a big question right here. Look, this question right here, I get all the time as a broker. Ooh, I love this one right here. The question is, when the contract says days, does that include weekends?
Mr. Ragsdale, it does not say business days, it says days. You have 8 days. The only caveat I can think of is if your 8th day to close fell on a Sunday, we can't close on Sundays because or Saturday or Sunday because the bank is closed. It would then go to that Monday.
Now, and let me say this, because this comes to me all the time. Days mean days, and this is what happens a lot of times. I receive a call. Oh, Mr. Broker, Luther, listen. The inspection said 7 days, and it was on a Sunday, and I couldn't do the inspection because it was Sunday. Now they want to take the earnest money because I'm out of contingency, or the appraisal was 14 days, but the 14th day was on a Sunday. I couldn't get the appraisal done on Sunday. Guess what? Days mean days. Now you can do a couple of things to do this. One, you can say business days. Now you're on business days. Or 2, you can put in a specific date. But here's the deal. If you have 7 days for an inspection, 7 days, and if on the 7th day, it just happens to be a Sunday, okay? Or the 7th day is a Saturday, and for whatever reason, you couldn't get it completed, then the seller says, I don't want to move forward. Give me the earnest money, and you have no more, guess what? Days means days. And it comes to me all the time, and I have to, hit you with the unpopular news of days mean days. Here's another one. But the 7th day was on Christmas, or New Year's, or leap year, or Valentine's Day, or Thanksgiving. Guess what? None of that matters. Okay?
And what Mr. Ragsdale just said is correct. And I'll go back to what I said earlier. Now, if I look at a calendar and we're supposed to close on the 24th and I extend for 8 days, that 8th day is the 4th. You need to close on the 3rd because on the 4th day, your contract has expired. Okay?
Yes, the
next
questions.
Slide, oh, go ahead.
Do I have any questions? Oh, no. Okay, next one. Yes, got it.
All right. And this we've already talked about. I'm on the signature page. Please make sure you sign the contract correctly. Please, if there are 2 sellers, everybody signs the contract. Please, as an agent, pull the tax records, talk to the seller. Do not come to closing and find out one of the sellers is actually deceased. Make sure you know who's on title and both parties sign that contract. If somebody has passed away and the property is part of an estate, make sure that that is shown, and the person who has the authority as the administrator or the executor is the one that's actually signing the contract. And we already talked about personal or company. Next slide is special stipulations. And we did it out of order because it was so important to me. Special stips I've talked about. Please do not write your own special stipulations. Please go to the drop-down box and try to include those that are in there, because I don't want you to write a special stipulation that contradicts what the actual contract states. Because now, if that does happen, the court will interpret that contract against the person who actually wrote it, and that may be doing a disservice to your client. Are there any questions?
Questions at all? Questions. Let me check and see if we have any hands up. Hands up for questions. Hands up for questions. The chat is open as well. And I got my Q&A. Yes, a hand just went up. Yes, Sandra, what's your question?
I'm trying to get a better understanding when it says taken subject to existing loans. Can you elaborate on that a bit, please?
Well, that slide, actually, that's my fault. That's the type of loan that you have. And this is the way that you can take it subject to an existing loan is a wrap mortgage. And typically a bank will not give you a loan on that because a bank wants to be in a first loan position. These right here are things that I've seen people try to put in their special stipulations. They try to correct the earnest money. They try to put in the special steps what the amount of the loan is going to be. So these are things that I've seen happen, but you don't want to put these things in special stipulation because you don't know these things, and it causes a problem in the contract. So taking subject to an existing loan means I have a loan at Wells Fargo. I'm going to sell you my house for $100,000. I'm going to sell you my house, but you're taking it subject to my Wells Fargo loan, which either means that you're paying 2 mortgages on the house, or you're now going to basically assume my loan and start paying Wells Fargo in my place.
Excellent. Any other questions here? Looks like we've covered it all right on time. Well, again, Mr. Medley, please give everybody your contact information, website, phone number.
Hello, my name once again is Leonard Medley. Phone number 770-319-7592. Website www.mkalaw.com. And best email address is Leonard, Leonard, @mkalaw.com.
Absolutely. Once again, sir, thank you for everything. Always a great job. We truly appreciate it. Listen, Platinum Real Estate, we have queer opportunities. Call or text 404-994-4600. If you are not a member of the Platinum Real Estate family, you can contact us 404-994-4600. I would love to sit down, talk to you about career opportunities with Platinum Real Estate, or shoot me an email, careers@platinumrealestate.com. I will personally call you back myself. Mr. Medley, great job. Thank you for everything.
Thank you all very much. You'll have a great day. Be safe.
All right, talk to you soon. You guys, hey, listen, next week, every Thursday, 12:30, we have training just like this. To everybody in my everybody at Platinum Real Estate, don't forget, we have another coaching session Tuesday, 8:45. This coming Tuesday, 8:30, another coaching session, as well as next Thursday, we will have some more education right here. Thank you very much for everything. You guys, thank you. Talk to you soon. God bless you.